All right, everyone, I'm going to call the docket. When I call the docket, you need to stand and let me know you're here, and we're going to have a jury come up shortly. Christopher Esquivel. Jonathan Ramirez. Jonathan Giovanni Ramirez. Christopher Gill. Christopher Gill. Jamar Clark. Armando Garcia, custody. Raul Juarez, custody. Kenneth Keith Jones, custody. Christopher Gonzalez. Jordan Robbins.
He's here, Your Honor.
Thank you. Matthew Castillo. Matthew Castillo. Cristobal Gomez, custody. Genevieve Castaneda, custody. Mark Almos, custody. Jose Posadas, custody. Denise Thomas. Denise Thomas. Jesse Arriaga.
Here, Your
Amanda Mahula.
Honor. Here, Your Honor.
Aldo Salas, custody. Brenda Rodriguez. Mariano Rendon.
Here, Your Honor.
Matthew Rendon. Frederico Ojeda.
Here, Your Honor.
Zayden Ali. Christopher Weezer, custody. Mario Herrera, custody. Eloy Gonzalez. Eloy Gonzalez. Sergio Chavez, custody. Tony Howe, custody. Megan Hunter. Megan Hunter. Beatrice Newsom. Brandon Pena, custody. Angie Ford. Jonathan Gutierrez. Armando Garcia. Johnny Aguirre, custody. Anyone came in late or your name wasn't called? What? I'm sorry?
Matthew Castillo.
Just one moment. All right, yes.
Richard Knuckles.
All right, what is your case number or SID number? 975-830. Just have a seat, we'll get with you. Anyone else? Okay. Jonathan Ramirez and Deputy Laura, when they come in, they need to go in the box. Jonathan Ramirez, Christopher Gill, Jamar Clark, Denise Thomas, Zayden Ali, Eloy Gonzalez, Megan Hunter, Beatrice Newsom. All right, everyone, someone is going to jury trial today. So the jury is going to be brought up here at 10:30. And if your attorney is not here, I suggest you get on the phone and call them, because anything that is not taken care of this morning, you're coming back this afternoon. Attorneys, you know the court's rules. Please follow them, and it will be a fabulous Tuesday. So everyone, please confer. And please call the jury up here at 10:30. Okay.
The 187 at 10:30. This is the coordinator. Norma?
Excuse me, what's your name? All right, let me see what page you're on. All right, you'll need to take a seat in the box.
Judge, I'm sorry, did you call the address?
Yes, she needs to take a seat in the box. Excuse me, are you on the docket today?
I'm not sure, my attorney.
Yes.
All right, what's your name? You say Melina Crystal? What's your case or SID number? All right, just have a seat. And for those attorneys who are here for jury trial, please do not sit here. And then when the jury comes up in the hallway, you have motions. If you have some motion that needs to be heard, it needs to be heard before that jury's in the hallway. Otherwise, it will be heard at some later time. Excuse me, are you on the docket? All right. Are you on the docket? What's your name?
Christopher Gill.
All right, you need to take a seat in the box. Jonathan Ramirez. Jonathan Giovanni Ramirez. Jamar Clark. Denise Marie Thomas. Zayden Ali. Eloy Gonzalez. Megan Hunter. All right, who just walked in? Are you on the docket? Yes, you need to take a seat in the box. in the box.
Did you still want us to bring in me?
If their attorneys are not here, they're gonna have to come back in the afternoon. Who has an inmate? All right, if you could bring up their two clients. But we're gonna do jury selection at 10:30. Yes.
We went to your house, what happened?
Should I really tell that?
To your house or your?
No, house. So I went to my house and there was trash all over the lawn. And the doors were wide open. I go in there are people in there. And I'm like, you all need to go. And by the time I was able to get them out of my house, there was a crowd of people around saying, you really shouldn't be doing that. And then I woke up.
The main part. He paused for a long time, and I was like, shut up.
Then I woke up. So it was all fine.
So technically, but you know what? Technically, that house is available for SWAT.
No, it is not. Don't even play those games.
It's for the past year.
No, absolutely not.
You're invited, Renee.
No, I made.
Renee is not invited. After yesterday.
Oh, okay.
I'll invite you.
Steelers may give a couple more. No,
For the for the persons in the audience, if your attorney is not here, I suggest you pick up the phone and call them because a jury's going to be up here at 10:30. Anyone else, if your case is not taken care of, you're going to be back in the afternoon. And as I say that, everyone remain seated. Okay. Deputy Laura, we still have lights that are out. What
Yes,
happened?
Judge, what I was told, they were only able to replace the light bulb that they had, so they ran out of light bulbs, so they're still waiting for the end of the month. And they have part of the gate, part here, but they need at least an hour and a half to remove them and replace everything, so. And they
Okay.
told that today is not a good day to do that.
All right. Well, it's not their fault that they don't have enough light bulbs. Whoever ordered them or did not order them.
They haven't forgotten about us and we're on their list. I talked to the maintenance guy outside and he said that he has one side ready to get these doors replaced, but
Mhm.
he's waiting for the other side.
Ah. Okay. Hello. Oh, that came from Michael DeLeon. Yes. I think he had that and he had one that was of a longhorn in a field of blue bonnets, which was beautiful, by the way.
Did he keep that one or?
He did.
Yeah. Did he do the photography?
That I don't know.
Yeah. I'm gonna ask him, I'm pretty impressed.
Mm-hmm.
So. Yeah. My adverse going on my Oh, man, this is the first. Okay. First off, yeah. I'm not gonna force you a while. Thank you.
I'm in the way. Of food. It's Angie.
Okay.
Excuse me, are you on the docket? The person who's walking in with the backpack, are you on the docket? I'm sorry, what?
No, ma'am.
Okay, all right, thank you.
Yeah, sit in the first row.
Oh. But I gotta run the 175. I'll be right back. Is that okay, Norman?
I gotta run to 175. I'll be right back.
Did you ask Norma?
I did.
She is the judge.
I did.
Yeah. Where's your client?
He said there was an accident on the way, so he was slightly delayed. He said, he texted me that he's looking for parking right now, so.
All right, the jury will be up here at 10:30.
Okay,
All right, thank you.
yeah.
It's 2024 CR 008300. Two, 8303. They're all same thing. Yeah, bad thing. That's right. Thank you.
Jones? Jones? Yeah. Mr. Jones? Yeah.
Oh, yeah, that's right.
Dayton, have a seat in the first row. Yeah. I would like to edit what it on. I did not. Did I click it on that? Yes. I know, I would like to edit. Oh, no, I don't have this. Every time, the form, if I would go to you. You'll let me edit? Okay. I'm ready.
Make sure every time before you select the form, it says. Okay.
Yes. Okay, thank you. All right, could I see the file on Jose Mata, please?
No,
Posadas,
my client is a Spanish speaker. May I bring up the translator?
Yes. Yes. It's Jose Posadas Mata. I think that may be turned around. Thank you. And counsel, I'm assuming you no longer want your motion for continuance heard? Okay, all right.
and Juarez. Yeah. Juarez. 14. Stop talking.
Hello. Counsel, the interpreter is here. All right, are you ready? Okay, sure. All right. If you'll have him come down. All right, court is calling 2023 CR 8607 State versus Jose Posadas Mata. Can I have parties announced for the record for the state, for the defense?
Damisela Chavira Brown, the defendant.
And are you Mr. Mata?
Yes.
All right, if you'll raise your right hand for me, please, the interpreter. Do you solemnly swear and affirm that you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record.
Your Honor, the interpreter's name is Jorge Valle.
All right. So counsel, you filed a motion for continuance. Are you still proceeding with the motion for continuance?
No, Your Honor, I'd like to withdraw that motion, please.
All right, then the motion will be withdrawn and not ruled upon. And it's my understanding state you tendered a dismissal?
That's right.
All right. So Mr. Mata, the state has tendered a dismissal because the complainant is waiving prosecution. So that just means that the complainant is waiving prosecution. It would probably be in your best interest not to talk to or go near the complainant. Do you understand?
Yes, yes.
All right, then I will sign the dismissal.
Thank you, Judge.
Is there anything else?
Nothing further.
All right, we can go off the record. You'll probably be released at midnight. That's the way the system works.
I understand.
All right, thank you.
Will you be excused?
Yes.
Thank you.
Have a seat. Toma asiento.
Raymond, how's it going today? Busy, busy.
Busy. Oh, yeah. Gonna be a busy week, I think.
Ah. Who's here on Christopher Weezer?
Present, Your Honor.
All right. Mr. Weezer, if you'll come down. All right, thank you. Court is calling 2024 CR 6089 State versus Christopher Weezer. Could I have parties announced for the record for the state,
Daniel Rosenberg for the state.
defense?
Rene Munoz.
And are you Mr. Weezer?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Is there an application in this case?
No, Your Honor.
All right, Mr. Weezer, did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am, I did.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, sir.
Habitual.
All right. Yes.
We are waiting the habitual.
No
All right,
objection.
any objection?
No objection, Judge.
All right, off the record. The person who just walked in, Deputy Laura, are they on the docket? Excuse me. You with the high ponytail who just walked in? Sitting next to the guy in the black suit jacket with the gray top? Yes. Are you on the docket? All right, thank you. All right, we're back on the record. Did you review the document entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of violation of bond or protective order 2 times or more within 12 months? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
That is correct, Judge.
Mr. Weezer, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
All right, off the docket for a moment. Counsel, don't approach over here while we're on the record because it interferes. Yes, that's okay. All right, we're back on the record. According to the plea bargain agreement, punishment is to be assessed at 7 years in the prison. There are no applications. The state is taking in consideration 2024 CR 6090, 2024 CR 6091, 2024 CR 5923, and there's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motion?
No, Your Honor.
Outside the agreement, the state is requesting that you have no contact with Amanda Melchor, Melchor. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State officer states it's one.
No objection, Your Honor.
All right, and state, have you spoken with the complainant? All right, thank you. You may be excused. Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After hearing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
If we may, Your Honor,
Anything you wish to say on behalf of your client?
we're asking the court to follow the negotiated plea bargain agreement, Judge. I was talking to my client about some of the maybe drug issues he may be dealing with that is maybe a cause of him coming into the criminal justice system as he's done in the past. Talked to him about programs within the Texas Department of Criminal Justice, rehabilitative programs in terms of getting drug treatment, counseling, and help. And if he is granted parole, to take advantage of those programs that he'll have if he is granted parole after doing his requisite time on this case, Judge. So we did have that conversation, and we're just asking for the honorable court to follow the agreement, Judge.
All right, so what are your drug issues?
I had an issue with crystal meth that time grade, you know what I mean, and then it went. I have a 2-year-old that led to arguing with my spouse, and just spiraled into an ugly, bad relationship, went toxic, you know, and
Well, I mean, sometimes a relationship goes toxic because there's a person in the relationship
I was
who
the
is
person.
toxic.
it was me.
Yes.
And I do take responsibility for it. It's hard to swallow a 7-year sentence, you know what I mean, but I know that it's best for me to do that, get the help I need, and, you know, return and be a better father for my daughter, as well as my other kids.
All right, and so the mother of your other children, did you harass her as well?
But yes, we had an issue with fighting, going back and forth, same thing. It's a repeated cycle.
All right, court is going to find you guilty, sentence you to 7 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. The court will take in consideration 2024 CR 6090, 2024 CR 6091, 2024 CR 5923. There's to be no contact with Amanda Melchor. There's to be no unsupervised contact with minors. And I'll request the therapeutic community for you. However,
What is
I
that?
have no authority. I'll explain to you what it is. However, I have no authority for them to force you into that program. You'll have to request it. The therapeutic community is supposed to address any issues you have with substance abuse, maybe anger management.
The minor part, what is that about?
Oh, that means that if you want to have contact with your children, you're going to have to go to court, because for me, you will have to have someone supervise those visitations.
Oh, okay. Yes,
Okay.
ma'am.
All right. Is there anything else with regards to sentencing?
Nothing further with regard to sentencing, Your Honor.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, so we can get off the record. Here's the thing. You're going to go to prison. You're going to do your time. I hope that you will learn to control your anger. I hope that you will learn that when somebody says a relationship is over, you know, you're an adult. Don't try to win them back. It's over. If they want to get back with you, then they will probably reach out with you. But don't get out of prison and say, you know what? I have changed, and start knocking on people's doors, because if you do, you're going to end up right back here because you're going to have another violation. All right.
Yes, ma'am.
And don't get angry if there's another man that starts raising your children. You know why? Because you're at the prison and somebody needs to help raise your children. Okay.
Yes, ma'am.
And when you get out of prison, if I'm still here and you need to find a place for help with mental health issues, drug issues, or anger issues, you can come back here and I will pick up the phone, call a place, and direct you to where you need to go.
Yes, ma'am.
All right. Good luck to you. Okay.
All right, thank you.
You're welcome.
Thank you.
I don't have, thank you.
Thank you.
You're welcome.
I'll give them their copies. Here's one.
Sure. Hi,
Thank you, Your Honor.
all right, thank you. Have a good one.
His number? He's a MTR.
All right, who's here on Megan Hunter?
Present, Your Honor.
All right, where's Miss Hunter?
Your Honor, despite best efforts of defense counsel have not been able to make current contacts with her. Although we had previously established contacts, that contact has fizzled out. I was aware that she had a court date today for the violation report that was filed with this court through pretrial services notification. However, I still do not have contact and I do not believe she is here either, Your Honor.
All right. Then the court is going to rule on the violation report. And the court will issue a judge's warrant, remand your client without bond. If your client makes an appearance, the court will reconsider.
Definitely, Your Honor.
All right, thank you.
Thank you.
All right. Oh. All right, who is here on Angie Ford? All right, you ready?
Yes.
All right, have her come down. Angie Ford? So council, are you ready to proceed on the motion to revoke?
I am, Judge.
All right, court is calling. Court is calling 2021 CR 4750, State of Texas versus Angie Ford. Can I have parties announced for the record for the state?
Continuance, Voir, State of Texas.
Brent Harvey for Miss Ford.
And are you Angie Marie Ford?
Yes, ma'am.
All right, Ms. Ford, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? All right, you seem to be looking towards your attorney. It's this document that states what you're on probation for and what the state is saying you did not complete. Did you review that with your attorney?
Yes.
And did you understand it? Are you the same Angie Marie Ford who was placed on deferred adjudication in 2021 CR 4750 for the offense of possession of a controlled substance, penalty group 1 gram to 4 grams on July 20th, 2021 for a period of 3 years? Is that you?
Yes, ma'am.
All right, state.
Violating condition number 5, Bexar County, Texas, defendant Angie Marie Ford, then and there failed to report to the supervision officer as corrected for the month of June 2024 in violation of condition number 5.
How do you plead to that? True or not true?
Statement followed by.
Any objections to the state's waivers?
No objection, Judge.
All right, did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is, Judge, to extend the defendant's probation for 18 months. To first have the defendant go through a MIC evaluation and a drug court evaluation. And with either of those, she's not placed in the drug court to then have her drug Saturday.
All right, is that the proposed agreement?
That is the agreement, Judge.
All right, Ms. Ford, you want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth? So help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Sure.
All right, do you have any family support? So what drugs have you been using?
It was crystal meth.
Okay. And how often were you using?
I had stopped for quite a period of time, and but recently I've had a lot of things happen in a short span of time, and I did start using again right up until my arrest.
What things happened?
Somebody that I had been staying with, taking care of, he passed away, and he was like a father figure to me. Where after that, I was evicted from the property, shot and killed 9 of my dogs, put water in my gas tank. I didn't have no job. My truck was not running, so I was living in my truck, and it became overwhelming. Really overwhelming. Instead of reaching out for help like I should have done, I ended up back in an old neighborhood, and started using again. I couldn't handle everything all at once, and that's when I did not check in. The probation officer asked me to check in, and I guess I felt like because I didn't have support anymore, I kind of gave up, honestly.
All right. Probation,
Yes, sir.
what are you requesting on this case?
Just as Voir indicated, the extension of 18 months, drug court evaluation in custody, big evaluation in custody, and if not accepted into drug court status. That was the last recommendation for the TAP evaluation, Judge.
Okay. All right, and this person you were staying with that you say you were taking care of, how were you being paid?
Well, the room and board, and then he paid for any expenses, $1,300 was paid. And he was, the following week was, he was, gonna pay the rest of my probation fees, and he passed away.
All right, so did he pass away because he had medical issues and that's why you needed to take care of him?
Yeah, he had a heart attack.
All right, so probation and everybody, I want to make this clear because as part of your conditions of probation, you're not allowed to be a home health care provider. You're not allowed to be around minors or any type of employment with minors. And you're not allowed to be around vulnerable persons. A person who has a heart attack, a person who needs someone to care for them, that's a vulnerable person. And that's not allowed in this court when you're on felony probation. Do you understand? All right, the court is finding violation of condition number 5 true. The court is going to deny the motion, extend for 2 years. And again, and I'm underlining it, no employment as a home health care provider with minors. She is not allowed to be taking care of vulnerable persons. And if there's an adult that needs her to take care of them, they are per se vulnerable people. Otherwise, they could take care of themselves. There is in custody. There's going to be a referral to felony drug court. Is there a need for an updated TAP or no?
No, Judge, your tap is still good.
All right, if she's not accepted into felony drug court, she needs to go to safety. And you wanted a mental health evaluation, probation? And mental health evaluation, that will be in custody. Is there anything else you need from the court to be successful?
I was gonna ask for a faith-based program, for referral to something faith-based. That has been a huge, factor for me. I'm in Bible school on the outside, and I continue to do my classes and everything here, so if something faith-based would be really helpful.
All right, so let me explain something to you. If you could write your own program, you wouldn't be here on a motion to revoke. So you don't get to write your own program. You are either going to felony drug court. If felony drug court does not accept you, then you are going to safety. That's what's going to happen. And what's with the tattoo on your neck?
By God's grace.
Okay. All right. Is there anything else that you need from the court? Probation, anything else?
No, Judge.
All right. Thank you. Good luck to you.
Thank
Thank
you.
you.
I appreciate it.
Yes, thank you. Always good seeing you.
You too, Judge.
Are you feeling better?
You know, I'm not.
Oh my gosh.
Well, it's from diabetes. Sometimes it acts out and it's really a pain. Anyway,
Okay.
have a great day.
All right, you twos. You twos. Jamar Clark. Where is he? Okay. Could you pull the file on Jamar Clark? Yeah. You want to try calling his bondsman?
Yeah.
Okay. Eloy Gonzalez. Could you pull the file on Eloy Gonzalez, please?
Attorney Joe, you guys, one of the MPRs sent today, but there's a newly indicted, case, so I'm assuming he has more days on the MTR. On the MTR. Oh, okay, perfect. Is that since that's total for the whole, like, life of campus, or just got picked up on the MTR? 170.
By the office.
Okay.
For that.
Okay. Okay, perfect. Thank you. Logistics question. So if we think we're on MTR, we're not on the. We don't know why she's united students.
Denise Thomas?
Good morning.
Good morning. Why are you late for court? I'm sorry, what? All right, so here's the thing. Here's the thing. You've got to make sure that you're on time. You understand? All right, who's the prosecutor on Denise Thomas? Yes. All right, you're set for jury trial today.
State of Senator and Special Your Honor.
All right, so they're dismissing this case. They're saying because the complainant waived prosecution. I don't know any facts of your case, but what I do know is the state is only dismissing this case because the complainant decided they're going to waive prosecution. So it's probably in your best interest not to be around that person. You understand? Because what you're charged with, the range of punishment is 2 to 20 years. You understand?
Thank
There
you,
you are.
Your Honor.
Thank you.
Appreciate your time as always.
All right, have a good one. Could I see the file on Christopher Gill, please? All right, thank you. All right, who's the prosecutor on Gill? It's a DWI? Okay, so Mr. Gill came in late. His attorney filed a motion for continuance. I don't know if you have a copy of it, but he's actually in Del Rio in
Oh.
federal court. So of course, as we know, federal court takes precedent.
Yeah, I mean, I guess if you're asking if we're opposing it, we're not.
All right, Christopher Gill. Hello.
Hello.
Hi, why were you late this morning?
Cause the address of the assembly took me like 2 buildings down, and then whenever I got here, there was a long line of people like trying to get in as well.
Okay, you need to make sure that you're on time, okay? All right, your attorney filed a motion for continuance. He's in federal court. And are you employed?
I just got employed by IBEX. It's like a computer.
What is your work schedule?
My work schedule, they're gonna give it to me.
Hmm?
They're gonna give it to me this week. They're gonna give it to me this week.
Oh, okay.
Yeah.
All right, so what I'm gonna do, I'm gonna have you come back on October 31st.
Okay.
All right, Ms. Ferguson, give him a reset for October 31st. All right, we'll see you then.
All right, thank you.
All right.
I'm sorry.
Independent. No, I need your email address. Send like this defendant's email, defendant's email. Write it up. Right.
Oh, okay.
Oh, that was like.
I think maybe check up on that. He's got several 30. Used to.
Used to know a lot about this.
But it's. I think this new system, he likes it about my client. Oh, I got it. It's good. I don't think okay. Okay, what is it? I'll pull them.
Yeah.
I can see the court's jacket. There might be some bond information in there. Clark. Clark Bond. Hey, Judge.
Huh?
Could I see Mr. Clark's file? Court file. I want to see if there's a bond info in there. Oh, that's all you got.
That's all we have. They just do paper. But if you're checking to see if they have a bond,
Well,
where the bondsman is?
Yeah, they have a name, but they have no phone number. They have the company name, which is initials of 4 letters.
Okay, what's the initials?
YLNS, Bell number 2. You know who that is?
Mm-hmm.
Do you really?
Yes. That's Herman. Here's a number that's from Google.
Yeah, okay. Thank you, Judge. I've never heard of those guys.
Oh, they've been around for a while.
Have they?
Mhm.
Thank you.
And they're gonna ask for your client's name and SID number.
Oh, yeah.
So,
I'm gonna call right now.
okay.
I don't know that I want to. Sorry.
All right, thank you. Keith Jones. And there's a plea on 2 cases?
Yes, Your Honor. 3 on 2 and then dismissal on 2.
All right, and are there applications or no?
Yes, application for probation.
Is it agreed to probation?
No, it's opposed.
All right. Court is calling. And excuse me, if counsel, if you all move towards that end. Court is calling 2024 CR 008303 and 2024 CR 008302. State versus Keith Jones. Can I have parties announced for the record for the state? Defense?
Sharon Thorne for the defendant.
And are you Mr. Jones?
Yes, ma'am.
Counsel, have you received all discovery and did you review it with your client?
Yes, Your Honor.
And each cause number, the court will find that the state is in compliance with discovery. Mr. Jones, in each cause number, did you review the application for community supervision with your attorney?
Yes, ma'am.
Did you understand it and sign it?
Yes, ma'am.
And each cause number, did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, in each cause number, do you waive the reading of the indictment?
Yes, Your Honor.
State in each cause number, well, let's start with the cause number ending in 03. Are you proceeding on that as presented?
No objection.
And are you proceeding on the indictment as presented in 302?
Oh, we all good.
Mr. Jones, in each cause number, did you review the documents entitled court admonishments with your attorney? Did you understand it and sign them in all the appropriate places?
Yes, ma'am.
Did you understand, in one cause number, you're charged with tampering or fabricating physical evidence with intent to impair? And in the other case, you're charged with unlawful possession of a firearm by a felon. In each of those cause numbers, those are 3rd-degree felonies. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am. I understand.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, ma'am. I understand.
And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Jones, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
In each cause number, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each cause number, did you review the plea bargain agreement?
Yes, ma'am.
Okay. The plea page, which tells you what your agreement is with the state. Did you review that with your attorney?
Yes, ma'am. I did.
Okay. All right. And each cause number punishment is to be assessed at 10 years in the prison. There's a $1,500 fine. The state is opposing your application for community supervision, and it's the court's understanding there was no application for deferred adjudication. Is that correct?
That's correct, Your Honor.
The cases are to run concurrently with each other. And the state is taking in consideration 2024 CR 8299 and 2024 CR 00830. Did you understand that to be the plea?
Yes, ma'am. I understand.
Defense is at the plea?
That's correct, but I think it's 8301.
Okay, 8301. Thank you.
Okay.
All right,
Yes,
state is at the
that's-
plea?
Yes, ma'am.
All right.
And that's the plea, Your Honor.
All right. Any objections to the court removing from the plea bargain agreement where the state said they opposed your application for deferred adjudication since he's not applying for that?
No, officer.
No objection, Your
All
Honor.
right. And the reason why, make sure that's not there, because we've had incidences before where there's a big issue because that's there.
Well, thank you, Judge. Yes, that's. We're not applying for deferred.
And then we have to find a court reporter to see what exactly what was said.
Oops. Read that.
All right, did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
It's not.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then in the cause number ending in 02, how do you plead? Guilty, not guilty, or no contest?
No context.
And in the cause number ending in 03, how do you plead? Guilty, not guilty, or no contest? State any evidence?
It all, to the one that all happens in both cases.
No objection, Your Honor.
All right, state you may be excused. Did you review the waivers with your attorney? Did
Yes,
you
ma'am.
understand it and sign it in all the appropriate places?
Yes, ma'am, I do.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am, I understand.
In each cause number, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing, or are you asking for a PSI?
We're asking for a PSI, Your Honor.
Okay. All right, so I can give you a PSI, but it's going to be a little bit, it's going to take a while. So
Okay.
if you would like, I can just reset it for witnesses, and the state will bring me in his criminal history, and I can make a decision from that. Or if you would like, I can still set it for a PSI and a TAP evaluation, but it'll probably be 4 to 6 weeks.
Top evaluation, is that? Well, Your Honor, the big issue is he needs help with drug treatment, and so that's why we were thinking about the tax evaluation. You understand, it's about 4 weeks down the road. Or do you want to, or you want to?
Or if you would like, since he's in custody, you're saying the sole issue is the TAP evaluation. If y'all want to waive PSI, you can waive PSI, and then we can just have a TAP ordered, and then we can
Okay.
set it for you to have witnesses presented if you want
Sure,
witnesses.
that would be great, Your Honor.
2 weeks. All right, I need a 2-week reset.
1 second, Judge.
And Mr. Jones, are you waiving PSI and asking for a TAP evaluation only?
Yes, ma'am.
All right.
October 22nd.
What day?
October 22nd.
At what time? 9 o'clock?
Yes, sir.
All right, we'll be back on October 22nd. At that time, the court will make a decision on your application to be based upon, of course, the TAP evaluation and any other evidence that's presented. All right, so everybody else, you're gonna be back at 1:30.
Thank you, Your Honor, may be excused.
Thank you. So the people who are coming back at 1:30 are Escobar, Ramirez, just one moment. Let me put this in the file. Any updates?
Yeah, I found, he's at work.
Oh.
And he did not get any notice from anybody, me
All right.
included. So I was asking if he could come tomorrow.
Oh.
He was here last week and I didn't show up because I did not know how to find. I just got back on the list and everything's kind of.
All right, state, do y'all have any objections to Jamar Clark being called for tomorrow? His attorney is informing me that he didn't know of this court date and he's actually at work.
Oh. Yeah, this is my first appearance. I'm just. What? Okay. Just because A&M won a football game.
Judge, no, I mean,
Okay, all right,
we'll be here.
all right, we'll have him come back tomorrow.
Thank you, Your Honor. Appreciate the help.
All right.
Thank you.
So people in the audience, Norma, I need the list.
Oh, give me 1 second, Judge.
And Deputy Laura, you can take the inmates back when you're ready to take them back. Okay. Yes, okay.
No, you have a hotline. Okay, check it out.
Is that
I use them.
a standing connection?
I have a witness.
All right, the following people are to remain in court. Everyone else needs to wait outside and we'll call you back in. Jordan Robbins, remain in court. Christopher Gonzalez, Christopher Esquivel, Amanda Mahula, Matthew Rendon, Mario Ano Rendon, Frederica Ojeda, and Zayden Ali. All right, everyone, please move with a purpose because guess what? We have a jury that needs to take those seats. So Jordan Robbins, remain in the courtroom. Christopher Gonzalez, Christopher Esquivel, Amanda Mahula, Matthew Rendon, Mariano Rendon, Frederico Ojeda, Zayden Ali.
Hold on.
Wait outside.
Come back at 1:30.
Come back at 1:30 this afternoon. I'm gonna check. I'll be here at 1:30. So just follow their instructions.
Okay. I see. Okay, I'll do that. It's in the, down in there. Okay, I'll do that. Perfect.
On the second floor of
Okay,
go across, go down, and then you're gonna go around the corridor.
okay, perfect.
Behind this.
All right, where are the attorneys for these cases? Who's on Jordan Robbins?
So Donna and my attorney stepped outside.
All right, if you'll go outside and tell them they need to be back in here. Thank you. Who are the attorney for Christopher Gonzalez?
Good, she's present. We filled out paperwork already. We're gonna turn that in to the clerk and
All right.
you resolved it.
All right, thank you. Who is the attorney for Christopher Esquivel?
If they withdraw the motion, do they have to stay in the pro tem?
What motion?
Judge, it was a motion to modify, but we're gonna withdraw it.
Who is his client?
Beatrice Newsom.
All right, I need to see the file on that.
Yeah, it's unindicted.
All right, your excuse.
Thank you, Judge. We're excused. And then- Thank you.
I'm here tomorrow.
Yeah, just seize up.
Yes. So the issue is you're putting in there that they're paralegal or something? That's fair, because we don't provide services for paralegals.
Right, my investigator is both, but she's an investigator, it's not, we're not using her as a paralegal.
Okay, because that's what's in the motion.
Okay,
All
no,
right.
not using her
So-
as a paralegal. She's solely being an investigator, Judge.
Okay, but yeah, that was put in the motion.
Okay. I'll fix that.
All right, I'll take care of it.
Thank you, Judge.
All right, thank you.
And then just a heads up, I'm gonna file, hopefully today, a motion for a second chair, so I
Okay.
can, do you need me to bring it back an approach or you'll just, it'll
Yes.
make it wait? Okay.
All
just
right, thank
checking.
you.
Thank you.
Yeah, because sometimes with e-filing and Odyssey, it doesn't make.
Yeah,
its
it
way there.
doesn't make its way to your desk. I just wanted to double check. Thank you. Yeah. Okay.
Yes. I know you.
All right, who's the attorney for Christopher Esquivel? Is Christopher Esquivel here?
Yeah, I talked to you that he was gonna be ready. Late.
All right, Amanda Mahula. Where are you? Who's your attorney? Matthew Rendon. Who's your attorney? Mariano Rendon, who's your attorney? Frederico Ojeda. Who's your attorney? Zayden Ali, who's your attorney? Who is your attorney?
It's hockey.
All right, Mr. Robbins, you're up for jury trial. Everyone else, you need to be back here at 1:30. Everyone else, you need to be back up here at 1:30.
1:30, guys, come back at 1:30.
Can I see the file on Robbins, please?
So who's going, Judge?
Jordan Robbins.
Robin? Okay. So you have your family membership, right?
Yes.
How many family members? Okay.
All right.
I'll find you.
Yes. All right, and we are done. All right, you can put it up if you want to, well, how to do it? Okay, all right, no problem. All right. Thank you, Vashawn. Yeah.
Ready? I'll just put it on the desktop. It's already up there. So it's already planned. You know.
So
You just straight up
there.
It's up right now.
It's only.
And then
One I was supposed to.
So everybody.
Chris, nice to meet you.
Yeah.
Allowed. Yeah, you can be at your either, but once you're in here, you can be walking in and out. Make sure your phones are off. Okay, phones are off.
What's on the road?
Ready to go.
Is this one? One some? I gave you that one. Yeah. Just making sure I don't want to mess it up with it. Yeah.
In the far corner. You gotta go.
Ready, you want this down?
Yes, please.
Yeah, we went to the rest. You can move that. Like that. That's it, it's like it's fine. Yeah.
Excuse me, counsel. So I have your motion for community supervision. There is an application that you need to fill out. That's the court application where he swears to it. And also, I need to know if he is found guilty, if he is going to the court or the jury for punishment.
Angle it or anything.
Okay. Well, this motion that you all filed, it's saying, I request that the judge presiding place me on community supervision in, or the jury recommend to the judge presiding that I be placed on community supervision. So I think it would be best if you use the application that's over there. All right.
You're probably lying, you said no, everything. Kind of intelligence.
Excuse me.
No.
Deputy Moore.
Or stupidity, either one.
People who are not over here.
Trust me, I still get nervous.
There's no room for
You're
them.
fine. You'll do a good job, bud. I'd stay right now if you need to take that.
All right, everyone needs to make sure that your phones are on silent. All right.
This was in the computer? No idea where I can talk about. Yeah, just leave it.
All right, we're gonna go on the record. Court is calling 2022 CR 11724, State versus Jordan Luke Robbins. Could I have parties announced for the record for the state,
Daniel Rosengard.
for the defense?
John Floyd.
I'm sorry, who else? All right, and are you Mr. Robbins?
Yes, ma'am.
All right, so it's the court's understanding that if Mr. Robbins were found guilty, that he would be going to the jury for punishment. Is that correct? Now, the other thing, his family members wishes to be present in the court. They have been allowed to be present in the court. Any objections, which I know that this is supposed to be an open courtroom. I'm assuming there are no objections to family members being present.
No.
And do both parties stipulate, because there were other defendants who were in the courtroom, do both parties stipulate that the courtroom is in fact open to the public and no one has been excluded? State? Defense?
Yes.
All right, then we will bring the jury in and each side will have 40 minutes. I'm sure you all won't take the full 40 minutes. And counsel, I know this is your first time appearing before the court. And it's the first time that I think Raymond will be here in trial. This is the way the court proceeds with voir dire. I will give my opening instructions to the jury. It will probably help, we're off the record. It will probably help both parties if maybe nothing's repeated. That will make things move quicker. I'm sure Daniel will tell you that usually I go over all of the constitutional rights. I don't like for people to strike for cause in front of the jury, because when I was practicing and the judge would want us to do that, I would always think in the back of my mind, are the other jurors going to hold that against me and say, I can't believe she didn't want me. So don't do that. Just make sure that you ask enough questions so that once we confer after the jury is excused, I will know what reasons you have to strike. And then once your voir dire is complete, then you all will have a chance to discuss with each other on who you can agree on. Those persons you can't agree on, I'll take it up. Any questions? Yes. Tomorrow. All right. All right, thank you. We're going to bring the jurors in. Sure. All right, and state, you say count one.
Right here, you see this little box thingy right here?
What is right?
This little one to the left, it looks like the docking thing, it's that. And then that little PC is the PC, you're not click the other one. If you click the other one, it's under for oh, and resolve this shit. And you'll have to call somebody else. Ray? Step in. Yeah, for like a quick second.
They need to do about the counts.
Trying to keep you away from
Yes, and then is count defense state count one? Is that ag sex of a child?
That is yes.
All right, and counts 2 and 3 are indecency?
Yes, sir.
Okay. And that's indecency contact, correct? All right.
Start taking a look at theirs. You guys need to.
Yes. All right, we're gonna bring the jurors in.
Ready, Judge?
Yes.
All rise. Number one. First row, all the way to the end. First row, all the way to the end has the number on the seat. So reach your seat, you can sit. Second row on top now. On first row on the bench. Fifth row.
All right, everyone, please be seated. All right, everyone, good morning. Okay, see, that sounds like you all are not even awake, and I know you're awake. Good morning, everyone.
Good morning.
Awesome. All right, everyone, you are in the 187th District Court. We're on the 4th floor. I am Judge Stephanie Boyd. So where are you?
187.
Okay, see, everybody is sliding off as though this is when you sing Old Lang Syne and you just start loud on the first part, and then you realize you don't know the words to the rest. So what floor are you on?
4th.
What is the court number?
187.
And who's the judge?
Stephanie.
See, everybody just trail off. I know what you're saying. You're saying, we know where we are. Why is she asking us this question? This is why I ask this question to every jury that comes here. Because whenever we take a break, all of you must leave the courtroom. You can't stay here. And when we do that, it always happens that 2 or 3 people get lost. We've had people who have tried to go on another jury panel, and then other people we've had to search for them. We've had people who thought, oh, it's over, so they're on the Riverwalk, and we have to go find them. So that's the reason why I asked that question. So you're here today for a jury selection, and this is the state of Texas versus Jordan Robbins. I'm going to have parties introduce themselves to you for the state.
Daniel Rosengard for the state.
Hi, everyone. Raymond Saldana. Good morning.
For the defense.
Good morning, everyone. My name is John Floyd.
My name is Chris Jones. Good morning, I'm Jordan Robbins.
Okay. And does anyone recognize any of those parties? Okay. Now, the other people you see in the courtroom are here to witness this jury trial. They are related to Mr. Robbins. So the people you see sitting here and the people you see here are here to hear jury selection and also potentially to hear the jury trial. Does everyone understand? Sometimes you will see different people come in to sit in. A lot of times we have students who are interested in the practice of law. And so they will come in and they will observe. You will have people sometimes come through that door. The people who are coming through that door did not read the sign on the door that says, do not enter, we're in jury trial. So pay no attention to people who come through that door. The people who come through this door are usually people for me. Sometimes it's police officers for me to sign different warrants or different documents. The people who come through this door, when I have to sign different things or review different reports, are not related to this case. So pay no attention to that. Does everyone understand? Yes. In your possession, you have cards. So if you can everyone please raise those cards? Do not lower your card unless I tell you to lower your card. All right. So all of the people in this box, please lower your card. 15 through 21, please lower your card. For all the other people who have your cards raised, when a question is asked, you're going to have to stand if you can. The reason being is because the acoustics in this courtroom are not great for the court reporter. And the court reporter is trying to take down everything that everyone says. Every jury that I've had appear in this court, I've given that instruction to. So far, every jury has failed to follow that instruction. So I'm going to tell you what I told them. I have faith in this jury that if you are answering a question, you will stand if you can. So will you all be able to do that? All right, you can lower your card. To my left is the court reporter. She is taking down everything that everyone says, so she needs to be able to hear. And I always said, if I was in a position to make someone's job easier, I would. So to make her job easier, the tone that I'm using, if you could use that same tone, do not whisper. She will not be able to hear you, and you will make it a struggle for her. So keep your voice at this level and talk at this pace. All right, so you're here for a jury trial. And I know people are always saying, I would love to just have been called down for jury duty and ended up with a car accident or something that's involving money. Well, guess what? In order for us to have jury trials, guess what we need? Jurors. So in this case, this is a criminal court and we hear felonies. In this case, there are 3 counts. The counts are aggravated sexual assault of a child, indecency with a child by contact, and indecency with a child by contact. Those are the 3 charges. Now, when I speak to you, and when the state speaks to you and the defense speaks to you, they are going to be speaking to you in hypotheticals. Neither party is allowed to tell you what they think the facts are in this case. The only way you will know what they think the facts are in this case is if you're on the jury. So do not be thinking when they're asking you questions like, oh, is that what this case is about? Or, oh, is this what happened in this case? Because they are not allowed to. Does everyone understand?
Yes.
Now, how do cases get to criminal courts and felony courts? They get here by way of indictment. What is an indictment? The best way I can explain it to you is this way in layman terms. How many of you, and we're going to practice raising our cards, how many of you have ever had a traffic ticket? All right, so that streak still continues with bad drivers in San Antonio. All right, you can lower your card. I've had a traffic ticket before in my younger days when I was about 19 or 20. So here I am 2 years later talking about this. So anyway, when you get a traffic ticket, when I received my traffic ticket, it was back in the day where the officers had the writing pad and they give you a copy of your ticket. When you receive that ticket, the officer is saying, this is why I pull you over. Let's say they're saying you ran a stop sign. So that ticket will tell you, I'm pulling you over because you ran a stop sign. When you accept that ticket, you're not agreeing with the officer that you ran a stop sign. That ticket is to tell you what you're being charged with. And an indictment is to tell somebody what they're being charged with. I think everybody would feel it would be unfair is if you think you're being charged with running a stop sign, and when you get to traffic court, they say, oh no, you're here for, not following a yield sign. So an indictment is to tell somebody what they're charged with and where they need to appear to answer for those charges. Does everyone understand?
Yes.
It is not an evidence of guilt. You cannot consider it for anything. Does everyone understand?
Yes.
Is there anyone here who will hold it against Mr. Robbins because he's been indicted? Now, the next thing I want to talk to you about is the right to remain silent. Nobody has to give testimony against themselves. Nobody has to testify. When I was a defense attorney, I would tell you, I would have clients and I would tell them, there's no need for you to testify. The state hasn't proven their case. Or either I would have a client who would be so nervous because one, it's their first time ever testifying and they have a lot on the line, right? And then I would have some clients who stuttered. There are a whole host of reasons why somebody would not testify. You cannot hold it against Mr. Robbins if he decides not to testify. You cannot be Mrs. Kravitz from Bewitched thinking about, oh, I wonder why they didn't do this. I wonder why they didn't do that. You are not allowed to hold it against him. You are not allowed to consider it if you were beginning deliberations. Does everyone understand? Now, I always have people who would tell me, well, if I were charged with something, I would definitely be on the witness stand. And that's so easy to say because you're not charged with anything. Until you are charged with something, you don't know what you would do. So is there anyone here who would hold it against Mr. Robbins if he decided not to testify? All right, number 7. All right, thank you. Now, the next thing I want to talk to you about is the presumption of innocence. What does that really mean? What it means is that when somebody is charged with an offense, they are presumed to be innocent unless and until the state presents evidence that they have committed an offense. Does everyone understand? So if you were asked to vote right now on whether Mr. Robbins is guilty or not guilty, your vote should be not guilty because no evidence has been presented. Does everyone understand? Now, the question becomes, then what type of evidence does the state need, or what's their burden? Their burden is proof beyond a reasonable doubt. What does that mean? When I was in law school, we had to learn the definition of proof beyond a reasonable doubt. I knew the definition backwards and forwards. I had my first trial as a defense attorney, and I was so happy because I paused in the right place. I put the exclamation point where it needed to be. And then after that first jury trial, you know what happened? There is no longer a definition for proof beyond a reasonable doubt. So neither the state nor the defense can give you a definition of that because no definition exists. So when I was a defense attorney and when I was a prosecutor, I said, how can I explain this to the jury then? And I decided to explain it to them by telling them what it was not. So, for example, the building next door to us with the green rooftop, that's the historical courthouse. They have civil cases over there. So think cases involving money. The burden of proof for those type of cases is preponderance of the evidence. More likely than not, something happened. If you are ever on a jury deliberating and it's a criminal case and you are saying in the deliberation room, oh, I believe this happened more likely than not, you know you are not at the right burden of proof because it's proof beyond a reasonable doubt. The other burden they have in the civil court is when the state is seeking to terminate a parent's parental rights. They're saying you're a bad parent and we can't trust you with your children. That burden of proof is clear and convincing evidence. That's a high burden, but there's a higher burden than that. And the highest burden we have is proof beyond a reasonable doubt. Does everyone understand? Now, the next thing I want to talk to you about is fairness. What does that really mean? Because sometimes the state and the defense will say, can you be fair? And this is the example that I've seen people give. They say, you're excited about jury duty. And I know everyone is excited about serving. And you get up in the morning, you've mapped out your route, but when you get up, your car has been vandalized or somebody's broken in your car, they cut your tires or whatever, but you can't drive it. But because you're a good citizen, you say, well, I'm going to call an Uber, I'm going to take the via, I'm still going to make it. And then when you come up, you find that the jury that you're going to be on involves someone burglarizing a vehicle or vandalizing a vehicle. And what will end up happening is the state and defense will say something like, that would not be a good trial for you to be on, would it? You just can't do it. Let me just tell you, that's not what fairness means. This is what fairness means. If your car were burglarized or vandalized and you come to court and you discover that the trial is about someone who may or may not have vandalized or burglarized a vehicle, the question becomes, will you be able to listen to whatever evidence is presented to you and base your decision of whether somebody is guilty or not guilty just based upon the evidence that you hear? Because guess what? All of us come with different things that may have happened in our lives. We don't expect people to come in here without common sense. We don't expect people to come in here newly formed, like you woke up today and you were just born and nothing ever happened to you. The main issue is whether or not you will be able to listen to evidence and base your decision on whether somebody's guilty or not guilty on what you hear from the witness stand. Does everybody understand? Right. Now, in this case, there are two phases to a jury trial in Texas. The first phase, people always think it's the innocent phase, but that's incorrect. The first phase is simply, did the state prove their case or did they not prove their case? If they didn't prove their case, then it's not guilty. There is no, oh, I'm finding this person innocent. The first phase is, did the state prove their case? Did they not prove their case? Does everyone understand? Now, if the state didn't prove their case, that means it's not guilty, and there's no second phase. If you find that the state proved their case and you were to find somebody guilty, there's a second phase, and that phase is called the punishment phase. And that's where you decide what the punishment should be. Does everyone understand? Now, in this case, there are two different ranges of punishment. The first range of punishment is anywhere from 5 to 99 years or life in prison. Now, that is a wide range because when I say 5 to 99 years or life in prison, that means it starts at 5 years and you count all the way up to 99, and then past 99 is life. Does everyone understand? The other range of punishment is anywhere from 2 to 20 years. What does that mean? That means you start at 2 and count your way up till you get to the number 20. Does everyone understand? Now, people will ask you, can you consider the full range of punishment? And then what will end up happening, jurors will start raising their hand and they'll start saying, oh, no, I can't, or I can. Well, what about this? And I know what you're thinking is, well, if I had the information, I could tell you if I consider the full range of punishment. That's not how it works, because remember, I told you both parties would be speaking to you in the form of hypotheticals. So the question with range of punishment is this. In any case, in this case, what you will have to do if you find somebody guilty and you're deciding range of punishment, whatever information that is submitted to you through evidence, you have to know mentally and internalize, okay, the range of punishment is 5 to 99 years or life. Let me apply what I know about the case and decide what would be the best punishment. Does everyone understand? Is there anyone here who would not be able to do that? All right, 35. Now, the next thing I want to talk to you is about languages. Is there anyone here? English is not your first language. Raise your card. And make sure your cards are turned around so I can see it. All right, 28, 32, 33, 40. And if you'll lower your card once I call your number, 45, 55, 57, 65, 74. 28, what is your first language?
Spanish.
All right, have you been able to understand everything?
Yes.
Thank you. And thank you for standing. We're off to a good start. 32,
Spanish too.
were you able to understand everything?
Most likely, yes.
No, not most likely. Have you been able to understand everything?
Oh, yes.
All right. And did you go to school here?
Second?
Did you attend school here in the States?
No, ma'am.
How long have you been in the States?
10 years.
All right, thank you. Number 33,
Spanish.
have you been able to understand everything?
Ma'am.
All right, thank you. 40,
Filipino.
I love when Filipinos come. All right, have you been able to understand everything?
Yes.
All right, thank you. 45, have you been able to understand everything? All right, 55, have you been able to understand everything? Thank you. 57, oh, that's the first time. All right, have you been able to understand everything? How do you say hurry up in your language? All right, thank you. 65, have you been able to understand everything? All right, did you attend school here? How long have you been here? I'm sorry? All right, thank you. 74? All right, have you been able to understand everything? All right, thank you. All right, I absolutely love languages. When I went to school, there are some people who spoke 6 languages. I was so jealous. And they tried to teach me, my friend tried to teach me Navajo. I pretty much know how to say hurry up in every language. That's really all I know. I ended up taking French in school because I'm from Louisiana and I thought I would be retired at 25. And again, here I am 28 and not retired. And so I thought I would be living in France. And my friend was begging me to take Spanish with her, but I said, I will never need it. Now, here I am. Is there anyone here who has any type of travel arrangements or constraints? And please raise your card because once I pass you, I will have passed you and I will not come back that way. 7, 10, 12. Once I call your number, you lower your card. 18, 20, 22, 31, 38, 47, 52, 57, 67, and 70. 7, what's your time constraint?
This Friday and next weekend of the 19th.
All right, and what's the issue?
My mother's birthday and dinner with a niece in Dallas.
All right, and what's gonna happen if you don't attend your mother's birthday? She's gonna say, my baby doesn't love me.
She'll be 70, so she wants to celebrate in Las Vegas, so she might be a little sad.
Okay, well, let her have fun.
Yeah, absolutely.
All right, number 10.
I'm flying out to Georgia this weekend.
And what for? Okay. All right. Number 12.
I take care of my dad, so I have to be at appointments with him.
Okay, does he have upcoming appointments?
Yes, ma'am.
What days?
He has one tomorrow
What time?
at, in the afternoon is the tentative time frame right now.
All right, thank you. Number 18.
Yes, ma'am. I have to speak to my lawyer at 1400. And then that's 1800 tonight. I have a medical appointment.
All right, and you speaking to your lawyer because is it a civil matter?
Divorce, a terrible divorce lawyer.
Well, is your attorney a terrible divorce lawyer? Or?
He doesn't seem to be representing me very well.
Okay, all right, thank you.
And my mother, she's disabled, like she has severe back pain and problems. So I provide transportation for her and things like that.
All right, thank you. Number 20.
I leave Friday morning to take my granddaughter to New York to celebrate her 10th birthday.
Oh, wow. All right, thank you. Number 22.
Flying out of the country next week,
And where are you headed?
Costa Rica.
Ah, thank you. 31.
I'm traveling to Arizona. My 85-year-old mother is having a heart procedure Thursday.
All right, I know everything is going to go well. Thank you. Number 38.
Event on Friday afternoon and appointments to get ready for the social event.
All right, what type of an event is it? Oh. I've been running across people all downtown having their reunions. All right, thank you. 47?
One is for myself and my husband also schedule it, and the week goes on for at least 2 weeks.
All right, and what are the appointments for? All right, thank you. Number 52?
I have travel plans starting Thursday.
I'm sorry, what?
I'm traveling to New York on Thursday morning, and I won't be back till the 22nd.
Are you going with her for her granddaughter? You guys are traveling separately?
My sister and I planned this trip 6 months ago.
Okay, all right, thank you. 57?
I actually don't have one, I got my dates.
All right, thank you. 67?
I have going on my honeymoon on the 24th.
And where are you headed?
Let's go.
And I'm assuming if you don't show up, that's gonna affect the marriage?
My wife is probably gonna be pretty pissed.
Okay, thank you. Number 70? I'm sorry, what? All right, thank you. All right, so y'all have got a chance to see each other. Other than just meeting downstairs and standing out in the hallway, do any of you know each other? That's odd. Usually there's some school teachers. One time we had the current wife, thank you, and the ex-wife. So 69 and 75, you know each other? All right, 65, 69, how do you know? Oh, please stand.
We are high school friends.
Oh. Are you guys still friends? All right, thank you. All right, so I'm going to tell you all two stories. Both of these stories are true. First, I think jury duty is an inconvenience. It's not a sacrifice. And let me just tell you why it's an inconvenience. Your country only asks two things of you: pay your taxes and show up to jury duty. And they don't even ask you to do jury duty every month. It's once in a blue moon. And people tend to complain about that. But I tell you what, if it's 4th of July, everybody's waving flags. I love my country. It's the military, we wave our flags. But when it comes to jury duty, and people are always saying, oh, we love the military because they fight for our freedom. But then we don't want to do the simplest thing, which is jury duty. And here's where the inconvenient part comes in. You have to pay for parking. But the paying for parking, is that really a lot that the country is asking of you? No. Coming downtown and realizing that there are one-ways everywhere. Call your city council, call your commissioners. They changed that because they think that that will help with the flow of traffic. But really it doesn't. It makes people very frustrated because you see, if you just turn right, the building is right there, you can do it. But it's a one-way, so you have to go all the way around. And then you run to the basement. I see y'all running at 8 a.m. and I always tell people, slow down. It's hurry up and wait. So that is an inconvenience. And all your country is asking of you is two things. They don't even ask you to wave the flags for the 4th and for Memorial Day or Veterans Day. They ask you to pay your taxes and come for jury duty once in a blue moon. Here's a sacrifice. My uncle, who's since passed, and my grandmother, who's since passed, grew up in a small town called Grand Cane, Louisiana. He was super intelligent, and that was back in the day. All the teachers knew every student. And so the teachers would tell my grandmother, we've taught him all we can teach him, and they'd move him to the next grade. So when he gets to be a senior in high school, his sister and his sisters and his brother end up going to that same school. Bad news for them because the teacher said, we're expecting a lot of you because your brother's super intelligent. My uncle graduates. Vietnam War breaks out. And he goes to my grandmother and he tells her, because of the way the world is, The only way I'll be able to improve my lot in life is to go off to the war. So she had to sign for him. And that was back in the time period where there wasn't a touch tone phone. There wasn't rotary. And I know young people probably don't know what a rotary is or a touch tone is. That was where you would pick up the phone. And when you picked up the phone, an operator would answer and you would tell them what number you want dialed. That's why they would have all those songs like Beechwood 45789. Television, 3 stations. And you really couldn't say 3 because NBC, in order for that to work, the weather would have to be just right. Couldn't be wind. You had the little rabbit ears, you're putting foil on it to make it work. And guess what? Those 3 stations were not 24/7. At the end, when it would go off, when they got high tech, they would play the national anthem and you would just have a flag blowing on the screen. That was it. There wasn't a computer where you could email. There was only what people call now snail mail. So my grandmother and my uncle's sibling only knew you put his name on the envelope, you write his number, and you send it off. And my grandmother would just write Vietnam. My grandmother quickly learned that the one thing you did not want is the military showing up at your door, because that means that the relative is dead. So that was her firstborn. And she sent him off to war in a place that nobody had ever heard of. Nobody knew the geography. And there was no way for her to pick up the phone and call him and say, did you make it safely? She would get maybe a letter back 6 months later. So that's why when I see people who are, I don't want to do jury duty, this is not a sacrifice. And both parties, they want you all to listen to what evidence they present. Now, mind you, the defense, they don't have to present any evidence because it's not their burden. In law school, they would tell us that the defense, they could sit at this table, they can play crossword puzzles, they could chat. You know why? Because they don't have to prove anything. The burden never switches to them. The state has to prove their case beyond a reasonable doubt. Does everyone understand? Now, each party is going to have 40 minutes to speak with you. They may end up giving back some time to me. I always do a timer so that both parties will know they're getting exactly 40 minutes. My friend from law school decided to do civil law. I always wanted to do criminal law. She got called up for jury duty and she said, let's have lunch. I'm like, great. We have lunch. I asked her, how is jury duty coming along? She said it was fabulous. Now that I'm a judge, how could it be fabulous? She wasn't with me, right? And so I said, why is it fabulous? She said, it's just like when I was in law school, I'm at the back and I'm keeping my head down. I laughed. I told her we're going to be able to have lunch all week. So other than raising your card and saying, please pick me, the quickest way to be on this jury is remaining silent. And I say that story, it's a true story, but I say it so that you will remember to talk to each side because they're trying to see who would be the best persons to sit on this jury. And remember what I said about fairness. Fairness is not, oh, this is going to be difficult for you because we can't have juries without jurors. Fairness means that you will be able to listen to the evidence. And if you can come to a decision, you will base your decision upon the evidence that you've heard. Does everyone understand? Yes. All right, remember to keep your voice up and stand if you're not on those rows. All right, State, you may proceed.
Thank you, Judge. Good morning, everyone. All right, everybody's nice and awake. I'm wondering if you are excited to come in this morning because you thought that everybody around you may be paid actors and you may be coming out in season 2 of Jury Duty. I'm sorry to disappoint you, but we are the real thing. We are not actors. This is the system, and I thank you for coming in. Okay. This morning, when you were writing the what is that? The sheet where you put in all your information. Do y'all remember writing that in the iPad or in a tablet, or even when you first came in, do you remember writing your information? Yes. Yes, I know it could be frustrating, okay? Why? Why do I have to give this information? Why do I have to be here? Well, like the judge mentioned, it's very important that we have jurors like you today because we're trying to find those 12 jurors that are fair and impartial. During jury selection, ladies and gentlemen, I just want to adopt two rules. Rule number one, let's be honest, and rule number two, let's be respectful. We're not here to change anybody's minds. Everybody's going to have different opinions based on your experiences, based on life. So I'm just here to get to know you. And the way we're going to do this is I'm going to call on you. For example, juror number 4, what is your favorite ice cream?
Chocolate.
Chocolate. Is that the best ice cream in the world?
Well, for me it is.
Okay, who agrees with number 4? Raise your numbers. Remember, raise the numbers. There we go. So that's what we're going to do. I'm going to be asking questions. Now, you may not agree with juror number 4, but we're not going to convince her that strawberry is better than a chocolate, right? That's what's good. This is the manner that we're going to deal. So the first thing I want to talk to you guys about the law, right? We mentioned that the charge of aggravated sex assault with a child. So what exactly is it? So there are elements that we, the state, have to prove. On or about a particular day in Bexar County, the defendant intentionally and knowingly.
Excuse me, if you'll slow down, court reporter.
I'm sorry. Yes. Caused the genitals of a child younger than 14 to contact the genitals of the defendant. And the key word here is contact, right? And it has to be under the clips, the contact. This is what there's 3 ways of proving aggravated sex assault of a child. One of them is through sexual contact. The second way of doing it is through penetration. And it could be the penetration of the sexual organ of the child or the anus with anything. It could be the genitals of the defendant, it could be the finger, or it could be any object. And the third way of doing that is if it's oral sex, right? If it's the sexual organ of the child to contact the mouth of the defendant or the mouth of the defendant to contact the sexual organ of the child. And like the judge mentioned, it's first-degree felony. That's the punishment for this particular charge. Second one is indecency with a child contact. It's a lesser included of aggravated. So instead of aggravated, now we're going lower to the next charge, which is indecency with a child contact. And the difference here is that there's just the touching of the genitals. Well, not just, it's a touching because it's obviously serious. The child's genitals by causing the child to touch the defendant's genitals or the defendant to touch the child's genitals, okay? And the key word here is with intent to arouse or gratify the sexual desire of any person. Why? Because touching the genitals of the child on its own, it's not a crime. I'll give you an example. If you have a 2-year-old that needs a diaper change, what do you have to do? You have to touch the genitals because you have to wipe the area. That's not a crime. What is a crime is if you're doing it with the intent to arouse or gratify the sexual desire of any person. It could be the child or it could be the actor, right? Okay. And of course, that's the punishment range. Second-degree felony, it's 2 to 20 and lack of registration. I think this is the question that the judge already asked, so I'm going to skip that, whether you can consider the full range of punishment. The burden of proof, I want to talk about just so you can visualize what it is. The judge did explain this. There's different burdens in a civil case. It's preponderance of the evidence. Clear and convincing evidence is the next one when you terminate parental rights. So when you're looking at this, think of how much evidence is enough to convict. How much evidence is enough to find the person liable, which in this case in a civil case, or to terminate the rights. You need more evidence for terminating rights of a child. And then there's beyond a reasonable doubt, which is in a criminal case. Okay, in a criminal case, it is the highest burden. But I can't tell you what it is because there's no legal definition for beyond a reasonable doubt. But I can tell you what it's not. And that is, it's not beyond all doubt. I'll give you an example. If you go to the movie theater, let's say you go to the movie theater on a Saturday or a Sunday, it's about 2 p.m. in the afternoon. And as you're parking your car and you're walking into the theater, you start noticing that the sky is getting cloudy. You start noticing a breeze hitting your face and blowing your hair. You start hearing thunder. You go into the movie theater, you watch your movie, and when you come out, you see this. You're number 5. What happened?
It rained.
It rained. Who agrees with juror number 5? Everybody, right. Juror number 6. How do you know it rained?
Because the water on the ground.
There's water on the ground. Juror number 7. Or 7, right?
Yes.
What else can you tell?
The dark skies.
The dark skies, yes. Juror number 8, I'm pretty sure if you walk on the parking lot, you'll probably notice that the cars are wet. Okay. So question is it possible for the San Antonio Fire Department to come into the parking lot, pull out their hoses and start spraying all the cars and give everybody a free car wash. Is that possible? Yes, it's possible, but it's not reasonable, right? I don't have to rule out every single possibility that could have happened. It has to be beyond a reasonable doubt. So I do not have to bring in the fire chief to tell you that they did not respond to the parking lot to give everybody a free car wash. Does that make sense?
Yes.
That is, the key word is reasonable. The judge also touched upon this already. One of the things that I do want to mention to you is the right to discovery, the right to confront witnesses, subpoena witnesses. Those are the defendant's rights. All the evidence that we have in this case, we have to turn over because that is what the law requires, okay? It doesn't work the other way around, right? I have to disclose all the evidence from police reports, officers, statements, videos, everything to the defense, okay? That's the rights that they have. But what is evidence? And before I get to what is evidence, I want to talk about what is not evidence, okay? And that is the defendant's criminal history, if he has one. I cannot give you any of this information, okay? That's part of what the law requires. I can also give you police reports or law enforcement documents. That's considered hearsay, okay? I'll do you one better. I don't have the reports, but I will have the officer come in and testify exactly to what they observed that day, okay? And of course, any footage, body cam, generally, that's also not admissible because it's also hearsay. Again, you'll have the officer here to tell you exactly what happened under oath. I do also want to mention with regards to the prior statements, the only thing we can talk about is what the accused said, what the defendant said, but no other party. Now, there's a forensic interview. Those are recorded statements. And the forensic interview is important because I want to mention to you all that it's the interview when there's a child and a trained professional at the Child Advocacy Center. Okay, this interview is done, and the questions that they're asked are open-ended. They're not suggestive. It's also not as intimidating as talking to a police officer. So that interview is recorded again. Generally, that's also not admissible. Why? Because the child will be here and testify to exactly what they said. So everything, bottom line is everything that is not before you in the back in the deliberation room, that's not evidence, okay? If it's gonna be evidence, you will have it with you, and that's what's gonna be considered for your deliberation. Now, what is evidence? Who watches SVU, Law and Order, and Criminal Minds, and all those shows? Raise your hand if you watch those. Really, not that many? Okay, well, for those of you that do, I know these shows are exciting. They're meant to be exciting. They're also meant to, you have the crime, the arrest, the court, everything is resolved within an hour. That's not in real life, okay? So I just want to talk about you probably may have evidence that you may see as photos, audio recordings, videos, maybe medical records, depending on the case. But what is the most important or most common evidence that you're going to find? And that is testimony. Have you all seen the movie, My Cousin Vinny? Yes? Okay. So testimony is important because testimony is evidence. Okay, you can consider the testimony as evidence. Now, juror number 10, how can you tell if a person is lying to you? You can't? Okay, well, juror number 11, what things do you look at whenever you try to figure out if the person is being truthful or not? Okay, eye contact, yes. And the reason why I'm asking, ladies and gentlemen, is because as jurors, or those 12 that will be selected, you get to decide whether or not you believe the witness on the stand. You can say, no, I don't believe what that person is saying, or I only believe 50% of what they're saying, or I believe everything of what they're saying. And the reason why I'm asking is whether or not you, what are the things that you do to believe a person is, yes, eye contact. What else?
Facial expressions.
Okay, demeanor, yes. Anything else? Number, juror? 13? 13. Anything else? Okay, mannerisms. You're right. So how a person says something. Eye contact, body language, tone. Those are important considerations. What else? 26?
The flow of the testimony.
The flow of the testimony. Okay. That's true. The content of what they say, right? Does it make sense? If a juror comes in and testifies and says there was a dog that was flying outside in across the street, well, you're gonna have to make a decision whether or not you believe that, right? Does it make sense? Cooperation. You may have other evidence, right, that may corroborate or not what the testimony that is said, okay? That's also, are there any consistencies, inconsistencies? Is there any evidence that corroborates what they say? So the key word here is, ladies and gentlemen, you as jurors get to decide who you believe, okay? That is one of the most important parts of being a juror. You get to decide. Now, I'm gonna ask everybody a question, and I would like for you all to pick one or two. Number one, a child makes up completely false allegations of sexual abuse. Or number two, a child denies being sexually abused when they actually were. Raise your number if you agree with number one. Raise your number if you agree with number two. Okay, I think it's pretty fair to say that everybody agrees with number two. Here's another question. Children make up allegations of sexual abuse to get what they want. One is often, two is sometimes, three is rarely, and four is never. Raise your number if you agree, and if you agree with number one. Raise your number if you agree with number two. Okay, 21, 52 in the back. Raise your number if you agree with number three. Okay, I'm gonna give you the numbers 1 through 7. You can put them down on 10, 9 and 10. 12 through 14. 15. 17 through 20. You can put it down. 22 and 23. 25 through 29. 30 to 34, 36, 38 through 43, 44 through 48, or actually 30, raise your number, 44 to 50, 51, 54 to 55, 57 through 60, 63, 64, 65 through 67, 69 through 72, and 73 to 75. Who agrees with number 4? Never. Juror number 8, 11, 16, 35, 37, 56, 61, 62, and 68. One more question. Children who make allegations of sexual abuse are blank, influenced / coached by an adult. Number 1, often. Raise your card if you agree with often. 35 and 43. Raise your card if you agree with sometimes. 1, 3, 5, 7, 8 through 11, 13, 14, and 15, 17 and 18, 21, 24 through 28, 31 through 35, 38 through 41, 45 through 48, 52 through 55, 62, okay, one second, sir. 67, 68, 69 through 75. Yes, sir. Number 50.
So found that one difficult to answer because I feel like there should be more context with it. For example, is it out of the blue? Is it at school? Is there a divorce going on? So that one, I didn't really answer because it seems too out of context.
So it sounds like maybe you might be a sometimes because it depends on the factors, right?
Context.
Yeah, context. It could be, I can't really give you a set of facts, but it just be in general. I mean, if you think that may influence, like we think a custody case, school, someone else can influence it, then you probably would be on the one or the two, but you would have to make a decision.
I have to make that decision now.
Well, if you just can answer it, that's fine. That's an acceptable answer. Where you just
It
say,
was just, it's difficult for me to say.
okay,
Sometimes.
that's fine. Thank you for bringing the concern. Who agrees with, do we do rarely, number 3? Okay, 2, 4, 6, 12, 16, 19, 20, 23, 29, 30, 36, 42, 44, 49, 56, 57 through 60, 61, 63, 65, and 68. And 66. Thank you. Raise your card if you have kids younger than 14. Okay, quite a few. You can bring them down. Do your kids lie? Have they lied?
Yes.
Yes? Okay. What do they usually lie about? Does anybody want to share about where you caught your child with a lie? 35?
Small things, just like, did you brush your teeth?
Are you supposed to be standing?
Yeah, apologies. Just small things. Like I said before, did you brush your teeth? Just normal things. Hey, did you get that extra snack out the pantry? Small things.
Okay. Does everybody agree that, well, I mean, everybody would have, I would imagine that at some point your child would have lied to you all at least once, right? Whether or not they got caught, it's a different story, but it's happened. Do kids normally lie to get into trouble or to get out of trouble? Out of trouble. Do they lie to make things easier or harder for themselves? So when you were a kid, actually raise your numbers. I'm curious. Raise your numbers if you ever lied to us when you were a kid. Thank you for being honest, ladies and gentlemen. Now, from those cards, raise your card if you've ever lied about being sexually abused when you were a kid. Okay. Okay, thank you. The whole point here is to let you know that it doesn't happen that often, right? It's rare when something like that happens. One thing that I do want to talk about though is I want everybody to imagine something, or more like remember something. I want everybody to remember the first time that you were intimate with your partner. Okay? If you haven't been, imagine a time that maybe you would be. But if you have, think of that moment. Okay. Who would like to share that? I'm just kidding. I'm not gonna call anybody. If you got a wave of discomfort when I said that, right? Imagine how a child is going to feel when they testify. Okay? How do you expect a child to behave when they take the stand? Anybody? Nervous? Okay. Scared? Juror number 15, what do you think?
Crying.
Cry, emotional? Okay. Juror number 18?
Maybe nervous to the point where they can't speak, possibly sometimes.
Okay. 45?
They might want to keep this, like for them not to like feel in trouble.
Oh, okay. 66?
I think that they might show some shame.
Right, because everyone is looking at you, right? As great people that you are strangers to the child. And it's a difficult subject matter to talk about and to discuss in public. Because at the same time, they're also doing it in front of the person that they're accusing. Do all children testify or react the same way? No? So, for those of you that have multiple children, they may have multiple personalities, right? Especially when it's two. It's normally polar opposites. Right? So yes, every child is different. Somebody might think it's normal and it's fine. Others, no, this is not good. This is not fun. So yes, every child is different. Now, I do want to talk about on or about. So at the very beginning, I mentioned to you all the elements that I have to prove and on or about a particular day. So our law allows us to use the words on or about a specific day. And that means that it's an approximate date. Why? Let me give you an example. Juror number 8. Actually, it's not very called you already. Juror number 9. Do you know who Kobe Bryant was? What month and year did he die? You don't have to tell me. But did he die? Yes. Right? It was, I mean, I don't expect you to go check if he's breathing or not, but I think it's fair to say that it's common knowledge that he died. Kobe Bryant, the basketball player, NBA star for the Lakers. But just because you don't remember the specific month and the year, does that mean it didn't happen? No. Children, who has taken their children to Disney World before or Disneyland? That is supposed to be an experience, the most happiest experience they've probably, one of the most happy experiences they'll probably have as kids. They're not going to remember the date when they went. They're going to remember the experience. What rides they got onto, who the characters they took pictures with. And that's why the law allows us to use on or about. Because sometimes it's unclear when this abuse happened. That doesn't mean that it didn't happen. Let me talk about memory. Juror number 17. Where are you? I called you already. Juror number 19. What is your earliest memory that you can remember?
Going to see with my family.
Okay. How old were you?
15. 15.
15, that's your earliest memory? Okay. What about you, juror number 20?
Probably when I was about 3.
Okay.
Just the old house I lived in and my dad taking us on motorcycle rides.
Okay. Do you remember who was there?
Mostly, yeah, only because of pictures.
Okay. What if you didn't have pictures?
Probably wouldn't.
Okay. When you think of your earliest memory, generally people don't remember all of the details. Do you? Or do you remember some of the details? Some, right? You also have to ask yourself, how many times have you thought of that memory before? Sometimes people think of it more than once, right? Would you agree? When you think about it more than once, do you remember it exactly the same way all the time? You're shaking your head, juror number 25. Tell me why.
Because you could misremember something or gain more details from the past.
Okay. Do you share, and for those of you that do share this memory with your loved ones or with your friends, do you normally share it the same way every time? And I mean like the same exact way.
I would say probably not.
Why not, juror number 4?
Well, because you start to remember other things, or you elaborate, and you repeated it to remember that memory, and you start adding other thoughts.
Raise your number if you agree with juror number 4. Okay, right. Just because at that moment when you recall the memory, you remember certain details, doesn't mean that you probably won't remember more details some other time, right? Or if you miss some details sometime, you may not remember those details when you're telling friend number 1, and then when you tell your mom, you may not give everything, but it doesn't necessarily mean that the general memory is false. It's there. But especially if it's happened so long ago, it's going to be difficult to remember. I do want to talk about the outcry, but before I talk about the outcry, and by the way, the outcry is the moment when a child discloses the abuse for the first time. And my question to you is, do you think children who have been sexually abused report it immediately? No. Raise your number if you don't believe they report it immediately. Okay, well, actually, let me Bring your numbers down. Let me ask the other way. Raise your number if you believe that they reported immediately. Juror number 28 and juror number 73. What are some reasons to why they don't report it immediately? Juror number 20?
They're scared.
Okay. 21?
Think that, they'll get in trouble or someone won't believe them.
Okay. 14?
Embarrassed.
Embarrassed, okay. 13? 14, I'm sorry. You're 14, right?
I'm 13.
13, yes.
They threaten them, they get threatened.
They get threatened. That's actually the first bullet point that I have. Fear. He said he'll hurt me if I told. No one will believe me. It's my fault. I didn't know what to do. I thought that what he was doing was showing me love. And I'm ashamed. Who said that? Somebody said it. Ashamed, right?
Scared.
Scared. Somebody said about embarrassment. Yes, they report to. When a child decides to report it, does the child not really report every detail of the abuse? This goes back to the memory slide that I talked about, right? What are some reasons why they don't disclose everything? Well, we talked about memory. We also talk about, let me talk about reactions. At that moment when the child is talking and saying these things, how do you expect them to be? Who said that? Juror number 3, emotional? Yeah. Do you all agree? The reaction matters. What matters is who you're telling, right? And what the response is when you are telling that person. What's the next one? 26, yes?
Sometimes I think they block it and it's not until something happens that it triggers a memory. And that's when they can, the outcry will happen.
Yes, and that goes to the next point, right? The triggers. How often does that happen to you when you see something or you hear something and you immediately remember something? I think everybody does. That's where they're triggers, right? It also happens to the children. Now, the outcry, it matters what time it was, the place where you were when you're first talking about this, and how you're saying it. We talked about delayed outcries, right? Children don't report it immediately. Sometimes children take weeks, they take months, they take years. And because it's delayed, do you expect there to be much evidence? Scientific evidence? I know everybody thinks of DNA right away, right? Oh, let's test DNA. That we can determine whether or not it happened. What if it happened years ago or months ago or even weeks ago? Probably not going to have any of that. Communication and perception are also important because sometimes the child may not know what that means, right? Incremental. These are the triggers that we were talking about with juror number 26. I want everybody to look at that question and imagine, what does a child molester look like? I can guarantee you, everybody's gonna have a different perception, different example. Was that what you were expecting? No. Do you all know who those people are? 26?
Can't remember, but she's a teacher, had an affair with her 6th grade student. I'm not sure if that second one's the subway guy.
Who said that? 67? 67. I actually had him there before, but I took him off.
Oh,
So
okay.
good try. Larry Nance, who's that? The doctor.
He was a doctor who molested a bunch of gymnasts.
At the Olympics.
Yeah.
Right? Okay. And who's the last one? Sports fans? Sandusky. Yes. Right? These people have something in common. trust, and access. This is what makes the individual dangerous. Okay? Where would a victim of sexual abuse most likely be assaulted? In a crowded area or in a secluded area? Where there are no what? Witnesses. Yes. Because who controls where it happens? The abuser, the actor. And who controls when it happens? The actor. Let's talk about this because sometimes when it comes to these kinds of cases, we forget about the outcry witness, which is the person that is receiving the information for the very first time. Typically, it's going to be a parent or a guardian. How does a parent react to these kinds of things? Who said sad? 63? Sad? Do you all agree with 63?
Angry.
Angry. 20 said angry. 19, do you agree? Do you all think the parents react the same way? No. Just like kids are different, adults must also be different. Some of them underreact, others overreact. Because there's different styles of parenting. If the person is different, some people may be more firm, more prone to anger, others are more prone to sadness. So you're going to have different styles. But the question that I do want to ask you is, will you hold the parenting style or the reaction of the parent against the child? Raise your number if you will. Okay. Police officers, I'm just going to talk about this very quickly. Raise your number if you have a family member that is a police officer. Okay, quite a few. Raise your number if you are a police officer. What number? 23. So police officers play the role of getting the information and then the investigation begins. Remember, just because they're a police officer doesn't necessarily mean that they get credibility points. You as the juror get to decide whether you still believe the police officer, okay? And typically there's a reporting officer and there's a detective that conduct an investigation in the case. Just like there are people that underreact and overreact, there's going to be good investigations and there's going to be bad investigations. Juror number 23?
Yes, sir.
Would you agree with that statement? There's good and bad investigations?
Yes.
I know because you work for the police, I know it's not good to talk bad about the department, but it's the truth. I'll be the first one to tell you that, I've seen that. So what should the state, meaning us, what should we do with those cases where we have a poor investigation? Should we just, dismiss it, can't prove it, it's done, we're done? What do y'all think? Anybody have any thoughts on those? 66?
Maybe dig deeper.
Okay, dig deeper. Does everybody agree with that? Is there anybody that disagrees? No, it's a tough question, I know. Juror number 50, right?
Again, another context, right? Is there a lack of evidence? Was something presented turned out to be false? Context.
Yeah, it could be both. Remember, I can't give you too many details, but in general, it's the concept behind it, basically, right? This is the important question. Are you gonna hold the complainant? Are you gonna hold the poor investigation against the complainant? You're shaking your head over there. Juror number in the back, white, 69? You say no. Tell me why. Well, I'm talking about the complainant. Yeah, 67, what do you think?
Putting on, putting on this whole show, so to speak, it's an expensive bit.
for everybody involved here, if there's really not enough evidence to take the thing to case, how are we spending this money to do this?
Okay.
You know, is it, if you have no evidence in the case, why would you bring it to court?
Who agrees with juror number 67? 29, 1 and 2, 11, 23, 24, 20, 52.
Again, it's not that I'm holding it against the child, so to speak. It's if there's not enough evidence to say the child did what he did or didn't do what he did. Is there enough to prove the case beyond a reasonable doubt, first off, and two, if there isn't, why are you wasting money and time?
Absolutely. 29, 73, and 58. 64. I would elaborate more on it, but I'm running out of time, so I'm gonna move on, but those are good points. I'm gonna ask this question for you all. What should be the goal of the criminal justice system with sexual abuse cases involving child victims? Should we rehabilitate or should we punish? Raise your number if you agree with number 1. Juror number 3. 13. 62 through 64 and 68. Raise your number if you agree with number 2. And I get the thing that everybody else who didn't raise their number would be under this. Okay.
Yeah.
What was that?
Can we say both?
Just depends on.
Well, you can. Raise your number if you agree it's both. Okay. Juror number 1 through 5, 8 to 9, or actually 8 to 12, 14, 17, 19, 21, 23 to 24, 28 to 29, 30 to 35, 37 to 43, or 37, 38, 39, 41, 42, 43, 44, 47, 48, 49, 50, 52, 57 to 59, 62 to 63, 67, 67 to 68, 69, 70, 72, 73, and 75. Final questions, ladies and gentlemen. Who here cannot sit in judgment of another? I think the judge may have asked this already. Is there anybody who just cannot sit in judgment of another? 35?
And I'm sorry, just to elaborate a little bit.
Sure.
because I know he was asking me about it. I understand the whole point of judging someone, we're here to judge a case.
Mhm.
The part of me that kind of gets to me, my conscience is a little bit about just after the deliberation, after we're getting to the point of, I guess, the punishment.
Of course.
Just don't feel like that's the right or the burden of the juror, should be the burden of the juror to come to that conclusion of what they should, you know what I mean?
Yeah, and that's fine. So the law requires, right, for us to be able to pull the whole 4-inch of punishment, but it's understandable if you just don't agree with it. Is that agreement okay?
Yes.
I'm just not.
Well, so there's a difference between being uncomfortable. I don't think anybody is, right? This is a difficult situation to be in. The question is, will you be able to actually perform it and do it? And that's where I kind of have to ask.
Yeah, I don't know.
You
I
don't
wish I could, but the subject matter is really
Okay.
personal to me, so I don't know.
All
Okay.
right, time?
Time?
Yes.
Thank you, ladies and gentlemen.
Defense, you may proceed.
Thank you, Honor. Good afternoon, everybody. Good afternoon, everybody. I know it's hard. We start in the morning, now it's afternoon. So first of all, I do want to let you know, we really appreciate everyone, coming through the process. As Judge Boyd said, both sides, right? We both want to have our day in court. We want a fair and impartial jury. And we can't do that unless all of you are willing to come down and do this and pay for your parking and everything else the judge was talking about. So thank you so much for paying attention and staying tuned in, okay? Obviously, when you heard the charges that have been alleged, this is a very, very serious matter. And I have the honor of representing Mr. Robbins One of the things that I always kind of start off when I'm talking about, especially these kinds of cases, it's because a lot of what Mr. Saldana said, right? I saw everyone raising their cards. Oh, you know, kids never lie about these things, right? Our kids are unlikely to lie about these things. So I always think about the other side of that question, right? Probably all of you have seen cases in the media, right, where there's been someone who's released after spending 30, 40 years in prison for a crime they did not commit. And that's what I think haunts all of us here. We want to make sure that everyone here is fair and impartial. Okay? So if everyone can commit to that, that's what we want. And one of the things the judge said earlier also is important to remember is if you feel that you are not an appropriate juror for this type of case, there's some kind of experience you may have, something you may think about this particular type of case, you need to let us know. If we don't hear it now, we can't, exercise our strikes. I mean, we can't eliminate people who are not right for this type of case until it's too late. You know, I've had trials before where we had jurors who were sitting on the panel after the trial began, and they said they just couldn't do it. They couldn't be fair. And guess what happens? We get a mistrial and we have to do all this again. So it's completely fine if you tell us, I can't do this in this particular kind of case. If it was a robbery or if it was a shoplifting case, you know, I can do that. But because of some experiences that I bring to this courtroom, I'm not an appropriate juror for this type of case. I have a bias. So we got some.
All right, before everybody raise their cards, and I'm gonna pause your time. Here's the thing. Sometimes people come to court and guess what? They're saying, I would love to be on a jury trial where it's about money. The issue about fairness is not whether or not it makes you feel uncomfortable. The issue about fairness is, regardless of whether it makes you feel uncomfortable or not, if you were seated as a juror, would you be able to listen to the evidence? That's it. Would you be able to listen to the evidence? And if you thought somebody were guilty, would you be able to find them guilty? If you thought they were not guilty, would you be able to not find them guilty? And I mean, would not be able to, would be able to find them not guilty. And if you couldn't come to a decision, then that's your decision. So the question is not whether it makes you feel uncomfortable or not. The question is whether or not you can be fair. And that means listening to whatever evidence is presented to you and basing a decision, if you can come to a decision upon what you hear. That's all fairness is. Everybody, I'm sure, would love to be on a case where it's at municipal court and maybe it's about somebody littering. But you're not. You're here on this case. So the question is not, do you feel uncomfortable? The question is whether or not you can be fair. Does everybody understand what being fair means? Now, with that being said, is there anyone here who could not be fair? You may proceed.
Thank you, Judge. And I want to kind of repeat what the judge said just a little bit. It's not even whether you can be fair or not. It's whether you have some kind of experience or prejudgment that says that you are biased, right? You come with a bias that prohibits you from sitting fairly in a case like this, okay? And so I saw the cards over here. Who raised their cards? Number one. Tell me why you can't be fair.
My father and grandfather both had were defendants in cases like this.
Okay. And how did those cases end?
Both found guilty.
Did you feel that they were treated fairly?
One yes, one no.
Okay. And does something from those experiences cause you to bring a bias, or you just say, I can't be a fair and impartial juror in a case like this?
Only in the case where I think one of them was treated unfair.
Okay. And but does that affect your decision? Would that affect your decision making in a case like today?
Yeah, I would like to think no, but literally as the first guy was up, that's all I could think about was my dad.
Okay. Okay. Does everyone see where we're going with that? Who else over here has raised a card? Number 10. Yes, ma'am.
My father also had.
Okay. Do you think he was treated fairly? Okay. Something from that experience that would cause you to be biased and not an appropriate juror in this kind of case?
Yes. Triggers.
Okay.
I'm
Thank
sorry, I
you.
can't hear.
She said triggered. You have to speak up a little bit louder.
Sorry, I feel like it would trigger something.
Okay, all right. That's another reason there might be a bias, right? If you are triggered by something you may hear that's going to prevent you from being fair and impartial, we need to know, right? Who else is on this side? 13, yes, ma'am.
My son was also involved.
Okay. And same kind of question. Do you think he was treated fairly? Okay. Something from that experience that would cause you to be biased, not an appropriate juror for this kind of case? Okay, thank you. Number 6, yes.
My cousin has had the same thing happen.
Okay. You're close to your cousin?
I'm very close.
Okay. And something from that experience that makes you think that you can't be unbiased in a case like this?
No.
Okay. Thank you. On the front row here. 18, yes, sir.
My mother was molested. And so I'm like a protector of my children, so.
Yeah, no, I understand. I mean, and before we keep going through this line, you know, my wife and I, we just celebrated our 30th year anniversary. We have 5 children, right? If one of my children were to come to me and say something like this, you know, I'd believe him, right? It's my job. I'm a parent. It's our job as parents to believe our children and take steps to make sure they're protected, right? Does anyone disagree with that? Right. But when you take the oath to be a fair and impartial juror, right, you become the trier of fact, right? And so that's why it's important we go through this exercise. I'm sorry, 18. I'm sorry. Someone move on down. And you can see, and we see these kinds of things in these cases all the time. And so I'm sorry, 18, that we had to bring that up. In this row? Yes, ma'am.
I was a victim as a child.
I'm sorry. You have to speak up because she has to.
I was a victim as a child.
And I'm assuming that that's something that is coming back to you right now.
Yes.
Yeah. You think it?
Move to the next juror, please.
Yes, Judge. 24. I'm sorry?
Same situation.
Okay. Further down the road, 25.
My best friend's daughter was a victim.
Okay. Same question to you. Would that prevent you from being a fair and impartial juror in a case like this?
If I divulge more,
Oh, you don't need to. You just need to tell us. Are you going to bring some experience with you? It's going to cause you to be
Yeah.
biased, but you won't be fair and impartial in a case like this. Okay. Here, third row, number 32.
Personal experience might trigger some.
Okay. You feel you can't be fair in a case like this?
Yeah.
You bring some bias with you? Okay. 35, yes, sir.
Yes, sir. Just the same. I think it's, I didn't have any experience myself, but I have family members. And at the end of the day, I'm not speaking for everyone here, but I have a kid.
Okay.
I have an 8-year-old.
I
And
understand.
man, I'm a protector of my family,
Yes,
just like
sir.
anyone else. For me to say without a doubt that I wouldn't bring some emotion in with that, I don't know if I can tell you that. Like I said, I haven't been in that situation, so I can't tell you that, but not putting my son or thinking about him during a case like this, I would think, I can't tell you that. So
Well,
I definitely have a bias.
And let me talk to you just a little bit about this. So it's understandable, right? You love your children, you want to protect them, right? I think all of us would agree with that. The question is, do you have some experiences or biases that you're bringing to the courtroom that would prevent you from being a fair and impartial juror?
Yeah. My family, yes.
Okay. Yeah, thank you for that. 38, Okay. Thank you, sir. 43, yes, sir.
I've been a victim as well, and I definitely carry bias.
Okay, okay. And is that why you talked earlier when you raised your card, when the prosecutor was asking you a question? There was something about making some kind of false allegation. Did you misunderstand the question earlier?
I just don't believe that it's going to make up false allegations just out of nowhere.
Okay,
Obviously, basically.
okay. Number 51. Okay. Thank you, sir. 46.
I'm just biased in the fact that kids are helpless. I can't listen to this.
Okay. Okay, no, I understand. Yes, number 50.
My wife, when by a family member, before we got married.
And do you feel that that I know you're a very nuanced kind of fellow, so I want to make sure we're getting this correct. So do you feel that you're bringing some kind of bias about this sort of allegation that would cause you to
I would like
be?
to say no, but then I would say, isn't that an inherent bias? So
Yeah, yeah. I think that's a good point. So you feel like you couldn't sit fair and impartial in a trial?
I feel like I could be fairly partial, but I think just that association, would that not be a bias?
You would have to tell us, right? If it's something that's still with you and present, and you feel like when you walked in and you heard what the charge was, that, hey, I've already made up my mind, or I'm already assuming that someone might be guilty of this. Does it create a bias in you that would cause you to be fair and not to be fair and impartial? I knew I was gonna have a hard time taking you down. Okay, thank you for that. Well, 61, yes, ma'am. Okay, I'm sorry. Thank you for that, though. 66?
I was not a victim, but my sister was a victim as a young child through teenage years. I don't think I was giving you advice, but I would be amiss if I didn't mention that.
Okay.
Since that's our close family.
Yeah, and I thank you for that. Thank you. 67? Okay.
I will be heavily biased.
Okay, thank you. I'm sorry. 73.
Family members within the whole field. I've also worked in mental health. Although I'm not practicing, I'm a licensed psychological associate, so I psych testing.
Okay. And thank you for offering that. Is there something from your experiences that would cause you to be biased in a case like this? Okay, you come with some sort of bias that would affect your ability to be fair and impartial?
Yes.
Okay, all right, thank you. We talked a little bit about I know that the judge and the district attorney talked a little bit about the burden of proof. Everyone here is fine with this concept of it's the state's burden throughout this case to prove their case beyond a reasonable doubt. That means they have to prove each and every element of their case beyond a reasonable doubt. Does anyone have any problems with that kind of burden being on the state? There was a movement at one time where they were talking about reducing the burden, or even maybe reducing the standard beyond a reasonable doubt in politics. And so I always ask, the judge also talked about the burden that's not on the defense. Does anyone have a problem with what the judge said earlier? If we wanted to, we could rest at the end of the state's case, not put on any witnesses, and the state would still be required to prove each and every element of their case beyond a reasonable doubt. Would anyone hold that against us if we decided to do that? I think you're okay. Let me start over here. What's your number? 2. Why do you think that a defense after a state put on their case would choose not to call any witnesses?
defense not choose to call witnesses?
So let's say the state proves that, they go through their case, they prove up everything they're continuing on putting for the jury. And the defense decides to rest. Why would it?
If the defense felt that the state did not prove beyond a reasonable doubt or even come close to that,
Right.
warrant any
Right.
further. The state made the defense's case for them.
Okay.
They're not providing enough
Okay.
evidence or testimony or whatever that proves.
So it's fair to say that you're comfortable with the fact that there's no burden on the defense to prove any
State.
on the state. Thank you for that. Did everyone hear that? Everyone understands that? Beyond a reasonable doubt, the judge talked about that there is no definition, right? Everyone heard that. It'd be a lot easier for all of us if there was. But there is no definition of beyond a reasonable doubt. What we do know, it is the very highest burden of proof in our legal system. Let me, number 3. Why do you think the burden is so high in criminal cases? If the state is required to prove the case beyond a reasonable doubt?
I think the stakes are much larger than other cases, like obviously losing custody of a child is pretty big, but I think when it comes to criminal cases, like life or prison, charges like that, we just need to be absolutely beyond a reasonable doubt, like sure that the accused incident happens.
Right, right. This is one of the things that's been built into the fabric of our constitutional system from the very beginning, right? There are other countries where they drag you into court and make you prove that you're not guilty. They might even torture you to get you to confess. But we don't do that here, right? So that's why this burden exists. The burden rests on the state the entire time. It never shifts to the defense. Okay. One of the other things I heard the lawyer who was smarter than me once say is one of the best reasons that we have this high burden, right? Number one is the first question I ask you. Are we certain that we dedicated our time and our intention in a way that when we come to that verdict, we're comfortable with it, right? The state has proved it beyond a reasonable doubt. And you, as the triers of fact, can go home and sleep without any doubt, right? Without any reasonable doubts. Did I do the right thing? Another thing that all of us talked about is defendant's right not to testify. Like, let's get you since you've had a chance, but yes, ma'am, what's your 5? Why do you think that someone might choose not to testify in their own defense?
It could be multitude of reasons. They could be uncomfortable speaking.
Uncomfortable speaking?
They could just not be able to articulate the things that they feel need to be articulated.
So maybe they're not articulate.
Like they don't know how to voice what they really want to say. Nervous.
Nervous, right? Can you imagine sitting on the stand as a witness, how it would feel knowing that your very liberty hinges on everything you say, and if you're nervous, you get it wrong. Number 6, what about you? Why would someone choose not to testify in their own defense?
Not sure.
Okay. I'm not ignoring you. In the back, what's your number? 8. Why do you think that a defendant in a case as serious as this? Now, I understand that there's going to be people out there who are going to say, if it was me and I was facing something so terrible, something so heinous, I'd want to testify. That's not what I'm asking you. According to what the judge said and what the prosecutor talked about, what we're asking you is, would you hold it against a defendant if the defense elected not to put the defendant on the stand, Would you use it as any evidence whatsoever in your deliberation? Okay? I think everyone committed earlier that they would not, right? So I'm asking back to you, why do you think someone would elect not to testify at the end of the case? He's afraid of being judged wrong. And your number, I should be able to count, right? 9. What do you think?
Considering they're, they aren't well spoken and they're not comfortable speaking in large crowds, so.
All right. Right. What if the defense attorney told, advised them not to testify because maybe the state hasn't proven their case? All right. There's many, many different reasons why someone may choose not to testify. So the question I'm going to ask is, after hearing all this, is there anyone that would hold it against the defendant if the defense elected for the defendant not to testify in their own defense, or would they use it as any evidence in their deliberations about the facts of the case? Anyone here that would hold it against?
Well,
Yes, ma'am.
well, I'm sorry.
No, that's okay. That's good.
I'm questioning myself because it's like, well, I would be fair and honest, but I really pondered there for a moment, like, would I be genuine about that, authentic in my ability to do that? I know it's weird. It's just, you saw me even
Yeah.
express it in my, I was pondering on that thought.
Well, so what's your decision? So, there's a joke that we hear sometimes at the courthouse is, I'm planning on going a trip to Vegas and my wife says, are you gonna be faithful? And I said, well, I don't know, I'm pondering about it. That's not the kind of answer that's gonna serve me well, right? So what we really need is a kind of affirmative answer one way or the other. So do you think you could completely put it out of your mind? I know you may want to hear, right? But that's not what I'm asking you. I'm asking you, could you put that outside of your mind and not use it as any evidence whatsoever in deciding if someone was guilty or not? Right.
I'd probably say no, because it's already a thought in my brain.
Okay, number 4,
All
thank you.
right, just one moment. Everyone, here are the rules. Anyone who's charged with an offense doesn't have to testify. The question is, if in this case, Mr. Robbins decides he's not going to testify, are you going to hold it against him? And what does it mean when I say hold it against him? That means that if you're deliberating, you're going to consider the fact that he did not testify. You can always say, oh, I wonder why somebody didn't testify, but you can't hold it against them. You can't use it as a part of your deliberations. Is there anyone here who can't do that? If he decides not to testify, is there anyone, if you're chosen for this jury and you're deliberating, you're going to go back during deliberations and say, strike against him because he didn't testify? Or are you going to consider it? Anybody who's going to consider that? 67. Thank you. Anyone else? 7. Anyone else who's going to hold it against him? And when I say hold it against him, I mean that you're going to consider the fact that he did not testify. Anyone here? 73 and 75, 30 and 8. Thank you.
Okay. Thank you, Judge.
You're welcome.
And so it's very important for us, right? This is a constitutional guarantee for anyone who is charged with a criminal offense. And just in case anyone hadn't raised their card already, would anyone use a defendant's refusal to or election not to testify against him in deliberations at all? They hadn't raised their card yet. Okay, thank you. What I want to do is ask a question now about, and I think we hit a lot of these earlier, kind of out of turn. From the people we spoke to earlier, you don't need to answer, and I don't want to bring it up again, but anyone else who didn't get a chance to talk earlier or raise their card, who is either a victim, had a close family member that was a victim, friend, a victim of sexual abuse, especially child sexual abuse, who thinks that that may, factor into their ability to be a fair and impartial juror. Anyone else that needs to talk about that? So do we have 71? Yes, ma'am. 71? Okay. Okay, thank you. 36? Okay, okay. I'm sorry I have to keep asking. I know sometimes it takes time for it to settle in, right? And for people to get comfortable speaking about it, but now you understand why it's so important. And there was one back here. I'm sorry. I'm sorry it has to be here. What's your card? 30. One of the questions, we'll shift gears. One of the questions that Mr. Saldana asked earlier was about, he showed you a question that had a couple of different options. What I want to know is, are there people in this jury panel who believe absolutely that children never lie about allegations of child sexual abuse? Never lie. Okay. I know we saw some law enforcement hands earlier, so I'm going to go through the same line of questions that I asked earlier about in the same way. Either yourself, close family member, very close friend who works in law enforcement. You start over here. Yes, ma'am. Number 5.
My dad is a police officer
He's a police officer. Where does he work?
in Converse.
Okay. Anything from those experiences that would cause you to give more credibility or less credibility to a police officer?
No.
Okay. Has he ever talked about his work?
He does.
And I'm assuming you've heard good stories about fellow police officers and bad stories about
Yeah,
fellow police officers. There's people like anyone.
Yeah.
Well,
My husband,
what did he do? Or what did you do?
he works in the Broncos.
He's a police officer?
Yes, he's firefighter and police officer.
Oh, wow. Well, he's really serving the community. Anything from those experiences that would cause you to give more credibility to a law enforcement officer that was testifying?
No.
Okay. Front row?
A distant relative, but.
That's not gonna impact it. 23, you are also. What kind of work do you do?
I'm with the San Antonio Police Department.
And what kind of cases do you handle?
I don't handle cases. I'm a lieutenant and I'm with the Chief's Technology Unit, so I primarily manage, oversee technology projects.
Okay, how long have you been a police officer?
16 years.
Have you ever worked in sexual abuse, child sexual abuse?
Yes.
Okay. And anything from those experiences that you think would cause you to be biased in a case like this?
No, I believe I can be fair.
Okay. Would you tend to give fellow law enforcement officers the benefit of the doubt, give them more credibility when they're on the stand?
No, I believe I have the ability just to listen to the facts presented.
Okay, thank you. 25?
I am not officer myself. I work alongside police officer.
You do what? I'm
I
sorry.
work alongside police officer.
Oh, you walk, what do you do?
I am, Bexar County Sheriff's Department on the hospital district police department.
Okay, so you work, are you a certified peace officer?
No, I work as their security manager.
Okay. Anything from those experiences that would cause you to have bias in favor of law enforcement?
No.
Back on this side of the room, 39.
From my wife, she's a constable.
For where? Bexar
She's a
County?
Constable precinct 2.
Precinct 2. How long has she been doing that?
It's going on maybe 5 or 6 years.
Okay. What kind of work does it do? Patrol or?
Mostly civil, just 25 years with Bexar County Sheriff.
Oh, I see. Did she ever investigate these kinds of cases?
Yes,
Okay. You've heard stories about these kind of cases before?
so
Anything from those experiences would cause you to have a bias in a case like this?
No.
Would you tend to give law enforcement officers the benefit of the doubt, give them more credibility than other witnesses?
No.
Okay, all right, thank you. In the back on this side, over here. Nobody, huh? I saw 71, but I think we're okay. I saw that we had a couple of nurses on the panel. Can you raise your cards if you're a nurse? 10, yeah, 18, 40. Oh, no, that, we'll talk to you. Can you stand up? Number 40, I'm sorry, but just so that before you can read. What kind of nursing do you do?
I see you.
You do ICU. How long have you been doing that?
20 plus years.
Wow, so you see a lot of trauma.
No, not really. I'm not a nurse.
Okay, intensive care. It's hard work. Anything that would cause, any experiences from your job that would cause you to be, to not be able to be fair and unbiased in a case like this?
A few. There's a few cases though, like especially women. I know we're talking about children, but with women also.
Yeah.
Like how women, sometimes they look like they were not being listened to
Mm-hmm.
or treated unfairly by, I guess, family members like that.
Right.
So
So you've seen situations where you thought someone was not being heard. They
Yeah.
weren't being
Yeah.
treated fairly because they
Yeah.
weren't being heard.
yeah,
Um,
it looks like crazy.
it looks
Well,
like,
don't listen to her because I think she's out there.
oh.
But I know we're talking about children, so I'm not really sure. I'm answering your question.
No, that's okay. So
Okay.
from those experiences that you've seen, I guess you've seen family members that try to maybe cover things up.
Yeah, looks like probably, yeah, that's probably.
Okay. Anything from those experiences you think that would make you unfair in a case like this?
Not sure.
You gonna go to Vegas?
I think I'm able to listen and not be biased.
Okay, thank you for that. I did see, is there another, yes, ma'am, 54.
Women's Health Emergency Department.
Oh, yeah, so you see violence against women, I'm assuming. What kind of cases do you see?
Pregnancies,
Mm.
leaders, oncology patients. On occasion, I do get cases like that,
Mhm.
but those cases are usually focused over to Methodist.
So if someone came in with an allegation or a report of sexual abuse, you would refer that out to another
We
unit?
can't refer them. As soon as they come in, we have to clear them, which means perform all the exams.
And have you done that before? Is that something you do?
Personally perform the exams, no, but actually take them in, chaperone the exams, treat them for possible STD. Yes.
Okay. Ever involve children? Okay. And same question I was asking the other people. Anything from those experiences that you think would, cause you not to be fair and impartial in a case like this? Okay, thank you. Any other nurses? How about school teachers? I think I saw some school teachers as well. Do we have school teachers? 30, yes, ma'am. Thank you. 41, yes, ma'am. What do you teach?
I'm not currently teaching, but I was a teacher in Colorado, and then I've been a stay-at-home mom for the past about 9 years now. And I substitute teach and tutor for the last couple of years through NISP.
So you said you have a lot of contact with children still. Anything from those experiences that you think that you need to tell us that would cause you to be, not fair and impartial in a case like this? Okay. Have you ever seen any allegations of sexual abuse before?
In my family, well, in my husband's family, but not in my professional.
Okay, okay, that's what I was seeing. Thank you. Thanks. Teachers, 40, or I'm sorry, what? 49, got my glasses. Yes, ma'am, what do you teach? Okay. You teach college kids. That's a whole different bird. Anything from those experiences have caused you to be, less than fair? Thank you. On this side, anyone? Okay. Well, since we covered so much material, I'm actually gonna be able to do what the judge said earlier. I'm gonna give you back some of your time and just let you know we appreciate your time and attention. And look forward to working with whoever is eventually selected to sit on the jury. So thank you all.
All right, everyone. I am going to let you recess for lunch. I'm gonna need you back here at 2. Look to your left, look to your right. You're responsible for that juror. So. All right, so everyone, please leave your cards with you and take your items, and we'll have you back lined up outside at 2. Everyone, please rise for the jurors.
Okay, please, I'll call you. They're hard. They're hard to explain. Two. Somebody take lunch. Don't think about it.